Okay. Let's try Polycom one more time.
All right.
Hey, let me take your, Shannon, take your phone with you and let me see what the screen is doing when you're logging in. Okay. Let's try Polycom one more time.
All right.
Hey, let me take your, Shannon, take your phone with you and let me see what the screen is doing when you're logging in. Hold on a minute. I got to turn off my my YouTube sound.
Yeah, that sounded like we already said all that.
Let's try. There we go. All right, doesn't look like it's working. So I'm going to go ahead and start. Do you have a copy of the docket handy? I had it open on this computer, but I don't want to keep jumping back and forth to screens.
Okay, what do you want me to?
Just a second. Let me do something else first. All right, let me just try this real quick. Oh, okay. Looks like I can jump back and forth pretty easily. Never mind. All right, I'm going to try to bring these people in. Let's see. Let's see who's on. Yeah, I am going to need your help. What's the name of the first case on the list?
Wilcox and Omer.
And who are the lawyers on that one?
Ron and Rapley.
All right, neither one of them are here. What's the next one up?
Hillary. Hilary.
Hillary, and who are the lawyers on that?
All I've got is Hotchkiss.
Oh, and he's disappeared. He was in there earlier, but he's gone now. What's the next one?
Garcia.
Any lawyers on that one?
Mike and Sean.
Oh, good. I got all of them here. Let me let them in. Oh, looks like Mike disappeared. He was just there.
Is he being a ghost on us?
I clicked on to let him in, and then all of us, he's not in, and he's disappeared from the waiting room. Oh, there he is again. I don't know what happened. He might have lost his connection. Okay, Garcia versus Garcia. We're not, our Polycom's not working. So counsel, this is not going on the official court record, but the YouTube video will be available to produce a record if we ever need to. So counsel, state your appearances.
Sean Curo appearing on behalf of the plaintiff by Zoom, and Christine Garcia I can see on Zoom as well.
Your Honor, Mike Kelly on behalf of the plaintiff, Jeremy Garcia.
Okay, and I don't have my file I was feeling just a little bit under the weather this morning, so I thought I better not take any germs into the courthouse. So refresh my memory, what's up today?
Judge, this is my motion. I originally had set it up for December 3rd, but Mike needed a little more time because of the Thanksgiving period. So I adjourned it to today's date. This is an objection by the defendant mother, Mrs. Garcia, as to the conciliator's recommendation that came out, let's see, October 26th of this year. By way of background, Judge, the parties moved from California to Michigan in August of 2019. They're both basically have been successfully or honorably discharged from the United States Marine. They have 3 children, Aiden, Emery, and Johnny. Aiden is 9, Emery is 4, and Johnny is 2. They all had moved into his mom's house, which was a 1-bedroom for those 5 people. The marriage had problems from California. Those problems persisted in Michigan. And my client moved out of that house with the children into a hotel for a period of time before she found her own apartment. And this is approximately September, early October of 2019. That after some period of time, Mr. moved out from his mom's house and moved into the same apartment complex, which is there across the street from Parkside. The parties at that time in October of 2019 started exercising a 2-2-3 parenting time schedule with all 3 kids. That parenting time schedule continued all the way through the filing of the divorce, which was filed August 5th, I believe, or August 14th of this year. At that same time, Mr. Kelly brought a motion for ex parte request to try to change the parenting time, noted that the parties had been exercising 2-2-3 since October of 2019, and Judge Jordan denied it, continued to keep 2-2-3 in place. We had conciliation on October 19th. The conciliation was Zoom and separated. It appears that Mr. Garcia went to Zoom first because in the afternoon when we went, the conciliator referenced that she had received some documents from Mr. Garcia, specifically some text from my client that we had never received. What I can tell you is they attached those texts. It is a 1-day chain of texts that my client, when she was frustrated, upset about the marriage breakup, upset about that they just moved from California to Michigan, were living in a single room in his mom's house, that she was just fed up that day. Said some things that maybe we regret from a standpoint of, life would be better without me. I should take my head off. Junk like that. 1 single day. That's it. For some reason, because that was given to the conciliator without us even having a copy during conciliation, the conciliator focused on that completely. She also received a letter from the daycare provider claiming that my client wasn't, doing as much as a mom with a daycare provider. Well, what I did is I contacted that group because the daycare provider, and I have my client contact them as part of Hanover Horton Schools. So they wrote a letter that said that particular person should have never wrote a letter, and that the things that she brought up were not unusual for all kinds of families, even families that are still together. Like the statements that were made were not out of the ordinary things. We see many families, parents especially, forgetting a mask or other items for a child. Children sometimes long to have one parent pick them up versus another. That this kind of stuff happens when there's not a divided family or a divorce pending. That the staff of Early Impression has witnessed and does witness in this situation. There's been no suspected issues of abuse or neglect. And if they did, they would have contacted CPS. So long story short, the conciliator got that letter from the plaintiff's attorney and or plaintiff. We didn't have it either during Zoom conciliation. She asked about that. We said, what, she might have forgot to take a mask for the kids when they were dropped off. There's been nothing significant at all that has occurred for the almost 12 months, full 12 months that they exercised 2-2-3 to suggest that it shouldn't continue. So what we have again attached to the pleadings by the plaintiff is just this, and I think it's from November of 2019, chain of text all the same day. Plaintiff doesn't date it, where my client is upset about life. So now they want to say she's suicidal, she's all this kind of crap, which is just, again, if it was a year ago, one, she'd never take any such steps. Whereas we provided, and I've attached for exhibits to you, the 911 responses to California in which Mr. Garcia was taken by ambulance. I attached the ambulance bill as well, in which he actually tied a sheet around his neck and was going to jump from a multiple story building to kill himself. He was then hospitalized. Front of the court doesn't seem to touch much on that. Why, I don't know. But again, I think a lot of it had to do with Zoom. They went to go first. She made her notes. She saw these documents. By the time we got on, she already kind of had her mind made up. If there was a concern about my client, why would you recommend 3 weekends a month? Because currently what my client has is 3 weekends a month, which doesn't make any sense. We have a 2 and a 4-year-old especially. Those kids should be seeing each parent on a regular basis. And the court sees that all the time, especially with a 2-year-old. Why is Johnny not seeing his mom in some instances? Because my client gets the first, second, and fourth week. So between the second and fourth week, we have over, 12, 10, 11 days that these kids don't see their mom.
No,
And so-
no midweeks were included?
There was no midweeks included, which I in my thing, I said, well, if you added Tuesday, Wednesdays of every week, this would be settled. Another thing the conciliator did, which I didn't seem to make sense, is cause the parties to have to meet for exchanges at McDonald's. Now, I think the parties have actually kind of gotten past that and still have gone to one another's house to pick up the kids. But why would you ever create it to have them meet at McDonald's, especially with 3 children? That doesn't make sense. My client should be picking up from school, dropping off to school on her weekends, and she should have midweek time for these kids. So, and again, I know you've got, I don't know how long a morning you have, Judge, because I can go on. There was a lot of things about this particular report. I mean, the only significant event I saw happen right before this divorce is Mr. Garcia was written for a high blood alcohol, like a super drunk in Washtenaw County. He ended up having to plead to an OWI, operating while intoxicated. He lost his job with Pepsi as a rep. He worked for their bottling company and went from $72,000 a year to, according to the front of the court, he says he makes roughly $29,000 to $30,000, which is about the same as my client. All of a sudden, then we get a situation where, because of the recommendation, my client has to pay child support to him, and I think they probably already hit it with a wage assignment. One other concern about that is the conciliator, I don't know if the court remembers, but we had filed a motion after the ex parte motion was denied. I filed a motion to get holidays in place because the parties were exercising 223, but they hadn't been a pinpoint on holidays. So on September 24th, you entered an order indicating that they would exercise holidays consistent with the front of the court handbook. And at that same time, because I was pretty sure, I was dumbfounded with the recommendation of the conciliator that we would have a 223 continue, that support based on where he was working, he'd have been paying support to her. Obviously, he lost that job probably because of the drunk driving offense, because he probably has to travel. And they did put a restriction of no alcohol, no drug use and that kind of stuff, but they didn't make it so he has to have it none of that 12 hours before parenting time. Be that as it may, these children have been texting, at least Aiden for sure, his mom, and communicating about how much he misses her. He wants to see her more often. It's gotten to the point where, fortunately, and I will give Mr. Garcia credit for this, my client now, she does a FaceTime communication with all 3 kids every evening. She doesn't have them at 8 o'clock. Now, there's no court order for that, but that's never the substitute of seeing them in person. She should have these kids at least 2 midweeks on top of these weekends, or go back to a 223 schedule. It attached as well, Judge, since they're claiming unsubstantiated claims that my client has bipolar disorder. I attached a letter. She worked for Dr. Van Wagenen, and Aaron Van Wagenen also provided a letter that he prescribes her medication, that she follows up with all her medical concerns, in his opinion, are under control. talks about her being an exceptional worker and an asset to his office. She's been working there since shortly after coming to Michigan. And we attached other letters from other people that know her, because no doubt in my mind, there was times when my client was angry at Mr. Garcia, very angry, because he had done things to her in California and Michigan that were inappropriate from a domestic violence standpoint. And sometimes she wasn't going to put up with it. Does that mean she might have kicked his car once and wrote something on it? She did. You better believe she did. We're not going to hide from that because he deserved it. She's never put these kids in harm's way, never would put them in harm's way. And we're not so convinced that he didn't move back to Michigan with them with the plan to file divorce anyway. And unfortunately, that's very upsetting to her, but that's the reality of what we have. These kids are too young to not see mom and dad on a regular basis. Neither one of these people is perfect. I can go on and on about some of the other issues about Mr. Garcia, but I don't know that that's helpful for this particular hearing. I just think the conciliator got it wrong. I don't think that having Zoom conciliations that are separate is easy. I think she saw that text that unfortunately you don't have your court file. When you read the text and the way it's been blown up, it looks terrible. I'll admit it looks terrible, but it's one single chain of text from November of 2019. Wait a minute, where's the evidence to suggest anything else, that there's ever a problem? Of course, Mr. Garcia has said all kinds of other things. Oh, she told me this, or she did this, or we had a disagreement about the child, or she kicked my car and wrote obscenities. Some of those things are true, but it doesn't mean you shouldn't see your kids. My client currently sees her own therapist. Her own therapist wrote me a letter today. Actually, I got it yesterday. He doesn't see why she doesn't have 50-50 with the kids. But again, that's too early. That's not what his job was. He's there to be her therapist. If they thought she had an anger issue, she's been enrolled in aggressive intervention or anger management type thing. I don't doubt that any Marine who comes in, both of these individuals don't suffer some PTSD. I think that's the only thing she's ever been diagnosed with. And bottom line is, that doesn't mean you're not a good mom. She's a tremendous mom. And unfortunately, dad led her to believe that he was going to agree to 50-50, 2-2-3. We went into conciliation with that understanding, and we're absolutely blindsided by the things that were said to us. She was amazed, just shocked. But unfortunately, they put too much emphasis on a letter from a person from the school who had no authority to write it and was a friend of Mr. Garcia, is now dating, has been now, I guess, since May, maybe June, one of the childcare employees where they were keeping their kids in childcare. A young lady named Dakota. As it turns out, Dakota's going through divorce. They have a custody battle going on. And her husband and my client have become friends because they have had a uniform approach to the idea that this husband and wife were going to have an affair. Well, we're going to go ahead and talk to each other and communicate with one another. Somehow they're trying to mix it up that that's evil or wrong. Bottom line is, my client didn't know about the affair until she could confirm it with Dakota's husband because it was being kept a secret. This was all before the divorce was ever filed. So long story short, Judge, and I apologize you don't have your file because I really wish you would have. 50-50, I think, is best. If we don't go back to 2-2-3, provide Tuesday and Wednesday overnights now each week, along with her 3 weekends in a month. If you want to set an evidentiary hearing, I even mentioned you could appoint a GAL in this situation because they can interview the parties, watch the parties interact with the kids, and interview and talk to the kids about circumstances to find out if there's any concerns about what's going on in either house. Thank you, Judge.
Your Honor, the minimization by Mr. Carroll is astonishing, but I think you're in a difficult position without your file there. I have emailed you a copy of the conciliator's report. I would request the court take a break, review that report and the entire rationale, because it's not simply, as Mr. Carroll was suggesting to the court, that Ms. Harsh made up her mind on one or two things. It's a number of things that are laid out within that report, and there's a number of admissions by his client as to these disturbing things. I would request you take the time to review that and then come back on the record and I can present my side of the argument if that's okay with the court. I think you need to be informed in that regard.
Judge, I don't have any objection. I didn't know. I don't know what email he's using to reach the court specifically. And Mike, did you just send the conciliator's report, or did you send my motion and your response as well?
I just sent the conciliator's report.
Okay. Does the court want anything more than that if we're going to do this?
Well, let me read that, and then I'll bring you back in. I've got a couple other things I need to do in the meantime. Let me just make sure that I got it. Well, when I've got a remote connection to my the computer in my chambers, but when I go through that, it's a little slow. So give me a moment here.
I sent it about 5 minutes ago, Your Honor.
I'm sure it's there. The problem is it's taken me a while to access it. All right, hold on. I'm gonna have to log in. Okay, I do have that email. Make sure I can open it. Okay, yes, I've been able to access and open it. Let me take a quick look at what else I got this morning. Let you know when to expect. Can you zoom back in at 11?
Judge, I will try. I think Mike Kelly's actually a GAL with me for a matter that we have first set up at 10 and then really at 10:30 in front of Judge Wilson. And I don't know that he would ever call our matter at 10. Probably won't be till 10:30. So we might be, I know I personally, and I know that he is a GAL. We were expected to both be on the Zoom. So it might be a little after 11:30, depending on what Judge Wilson's docket is. I've not checked his. Mike, have you seen anything about Judge Wilson's docket this morning?
It's pretty bad.
Yeah. See, and I think because it's Ron Fabian's on the other side with me, Tom might very well wait to the end. So we might very well be able to do yours in between and put the court on notice because, I expect I'll be Zooming all morning. So
Just let's let's shoot for 11. If you're running into a snag, if you could just let Shannon know.
Okay, thank you, Your Honor.
Thank you, Judge. All right, folks,
All right.
we'll zoom back in 11.
Your Honor,
Good morning.
Morning.
may it please the court, Your Honor, my name is Michael Brooks. My bar number is P22973. I've never been in your court before.
Well, actually, you're in my dining room today.
Well, thank you for inviting me to your home.
Yeah, so this matter is Dawson versus Dawson. We're scheduled for a pretrial this morning.
Yes,
You're the only two who have appeared, it looks like.
that's what I expect, Your Honor.
Oh, I'm sorry, I see Chris Dawson. Let me let him in. Who do you represent?
I represent Kelly Dawson, the plaintiff, and Billy Dawson. She is the plaintiff in this matter. Christopher is the defendant.
Okay, so this matter is set for a pretrial. Mr. Dawson, you do not have an attorney, is that correct?
That's correct, sir.
All right, Mr. Brooks, does it look likely we're going to have a trial in this matter, or is it possible that you're going to be able to work things out?
I'm unaware of the need for a trial. Mr. Dawson never filed an answer to the complaint. I defaulted him, sent him a notice of default, notice of this pretrial, obviously, and have scheduled this for a default judgment of divorce on New Year's Eve, which a copy of which Mr. Dawson already has.
Mr. Dawson, you are able to appear and participate in the hearing on entry of a default judgment. And if you have concerns about the judgment that's being proposed not being in the best interest, well, let me ask, is this a divorce with children?
It is.
Okay, I don't have my files. I was planning on being at the courthouse today and was feeling just a little bit under the weather this morning, and I thought I should
Please stay away.
stay home and people are safe. How many children do the parties have?
There are three. They're all
Three, and what
relatively
kind-
young, Your Honor.
Oh, she's shaking her head.
We
There are
got two.
two.
Oh, sorry. I'm I'm sorry, folks.
Okay. And how old are they?
Billy,
6 and 8.
thank you.
6 and 8. And what kind of custody parenting time arrangement is being observed currently?
I'll ask them, Your Honor, whichever one wants to answer.
We are,
We're following the FOC handbook. I get every other weekend with the midweek. My midweek, she's been allowing me to get the kids Tuesday after school. I get that COVID has affected that, but usually I get them Tuesday night and I return them to her after she gets off of work on Thursday afternoon. Although-
This seems to be working out well for both of you.
I mean, if we have to get a divorce, yes, sir.
What a court typically would look at with a judgment of divorce is what are the provisions for custody, parenting time, and division of assets and allocation of debts, basically, or whether there's any spousal support. Usually not, with a couple as young as you are.
There's not.
And if this current parenting time arrangement were incorporated into a judgment of divorce, Mr. Dawson, you could live with that?
Unfortunately, I mean, if she wants a divorce, that's what she'll get. I can't stop her or change her mind, so I'm not going to force her to be in something she doesn't want to be in. So,
May I ask Mr. Dawson a question, Your Honor?
Right ahead.
Mr. Dawson, did you get a copy of the proposed default judgment of divorce?
I did. I'm looking at it right now.
Have you read it?
I have.
Is there anything in there that you object to other than the fact that it is a divorce judgment?
Not that I can recall or that I can think of.
That's all, Your Honor.
So, Mr. Dawson, between now and, I'm sorry, Mr. Brooks, when did you say this was scheduled for a
New
default?
Year's Eve, believe it or not, Your Honor. You should talk to your
New Year's Eve?
office about that.
So that's fine. Mr. Dawson, if between now and the time of that hearing, if there are any minor tweaks that you'd like to have made after you've had a chance to consider that, can you just simply give Mr. Brooks a call? His phone number should be on the proposed judgment. Talk about it ahead of time. If not, I'll just plan on seeing everybody back here on New Year's Eve, and we'll get this finalized.
Mr. Dawson, he was talking to you.
I don't see any need to change anything. So if she wants it, she can have it.
Okay, we'll plan on seeing everyone back on New Year's Eve. There is a possibility that we can avoid that return, Mr. Dawson, if you find these provisions acceptable and consent to those terms. I can enter it as a consent judgment of divorce. I get that from what you're saying, you don't want to be divorced, but that's not really something that I can deny.
Sure.
Michigan has no fault divorce. So if Ms. Dawson believes there's no possibility of reconciliation, that's pretty much at the end of the inquiry for me. So what I'm going to do is I'm going to take some proofs in support of a consent judgment of divorce, so that if in fact you're able to get this signed by everyone and back into me, Mr. Brooks, there wouldn't even be a need for a default hearing.
All right. I'd be perfectly happy to do that if Mr. Dawson is.
Yeah, that's fine. If not, we'll just keep that date on as a control date, if nothing else, but we'll keep it on the calendar. So Ms. Dawson, I'm going to ask you to raise your right hand, please. You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
You can put your hand down now. State your full name for the record.
Billy Francis Dawson.
Go ahead, Mr. Brooks.
Ma'am, you have filed a complaint for divorce in this matter more than 6 months ago, correct?
Yes,
At the time of filing that complaint, had you been a resident of the state of Michigan for a period in excess of 180 days?
yes,
And a resident of Jackson County for a period in excess of 10 days?
yes,
At the time of that filing that complaint, you alleged a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed, and there remained no reasonable likelihood that the marriage relationship can be preserved. Was that true when you filed the complaint?
yes,
Is it true today?
yes,
Is there any chance of a reconciliation between you and Mr. Dawson?
no,
During the course of the marriage, there were 2 children born to you and your husband, correct?
yes.
Their names and ages?
Arabella and Zachariah. Arabella is 8, Zachariah is 6.
Are you pregnant at this time?
No,
You have reviewed and approved the proposed consent judgment. Is that correct?
yes,
I don't recall whether I had you sign it or not. But if presented to you in my office, you will sign it again. Is that right?
yes,
All right. And you are asking this court for the entry of a judgment of divorce.
yes.
I have nothing further.
Thank you. I'm satisfied, based on Ms. Dawson's testimony, that there's been a breakdown in this marriage. To the extent the objects of matrimony have been destroyed, there remains no reasonable likelihood the marriage can be preserved. I will grant a consent judgment of divorce upon presentment. As long as you get it into me before New Year's Eve, there will be no need to appear on New Year's Eve.
May I speak to Mr. Dawson for a moment?
Sure, go right ahead.
Mr. Dawson,
Yes.
I am going to send you another copy of well, actually, you have one in front of you. Could you sign that and send it to me?
Yes, at some point, yes.
Well, our time is just about up, as you know, sir. And so, frankly, I don't think the mail is very reliable for this purpose. Do you mind if Billy picks it up from you and brings it back to my office?
Possible, yes.
All right. I'll talk that over with Billy after this hearing. I think that's the only way we can assure that this is going to get done in a timely way. I have nothing further. Thank you.
So, Mr. Dawson, I had a question for you. Looks like you're wearing a uniform today. Are you in the military service?
Yes, sir.
What branch?
Well, I'm in the Michigan Air National Guard over at Selfridge, so Air Force.
All right. Well, I just wanted to thank you for your service, sir. Have a good day.
Thank you, sir. Thank you, Honor.
You know, I would like to do the same thing, Mr. Dawson.
Thank you, sir.
All right. Take care, everyone.
Thank you, Your Honor. Billy, I'm
You're
going to call you right now.
All right, thank you. Here's your.
Howdy.
Good morning again.
Morning. Am I the only one here? Okay, there we go.
No, I'm waiting for one more audio connection. So, folks, I wanted to let each of you know, your attorneys must be tied up in other courtrooms at the moment. What I'm going to do is get a message to them that when they are ready, that they let my court know so that I can reopen the Zoom meeting. I'm not going to just, well, actually, you know what I'm going to do? I'm going to stop the live stream. And when I see that those attorneys appear, and I'll keep checking on it, then I'll restart the live stream so that we can have a recording of the proceedings. So for now, I'm just going to put you back in the waiting room.
Okay. All right, sounds like a
Okay.
plan.
Okay.